Hello again, everyone. I'm attorney Robert Flessas, and thanks for watching this video. Cosigners, beware. And those who enter into a contract that required a cosigner should also take notice of this video, especially if it's a relative or an adult child or anyone else that cosigned for you. I'm going to discuss two areas of the law where cosigning works out for one of the parties, but puts the cosigner in a very bad spot. That situation is dangerous when the primary borrower to the contract files for a Chapter 7 bankruptcy. Well, let's look at this. Let's say you purchased the car, took out a loan as the primary borrower, and the lender required a cosigner because your credit wasn't good enough. After months go by, you file a Chapter 7 bankruptcy. Bankruptcy then gives some options when it comes to a car. First, you could sign a reaffirmation agreement that binds you to the liability for the loan. Second, you can elect to not sign the reaffirmation agreement and continue making the monthly payments and maintain the insurance on the vehicle. The third option is you can surrender the vehicle to the lender. Now, there's consequences under all of these. If the reaffirmation option is elected, both you and the cosigner are on the hook for the loan, whether you filed bankruptcy or not. Nothing really changes as long as you comply with the terms of the loan. If a default occurs under the reaffirmation option, then both you and the cosigner are both liable for the balance of the loan, just as if you never filed bankruptcy. Hopefully, the cosigner understands that result when inking their name to the contract. Most cosigners, though, don't even think about that scenario. If you elect to not sign a reaffirmation, then as long as you continue making the payments, maintain insurance, and complete the term of the loan, then no problem. But this option has consequences for the cosigner too. If a default occurs under the scenario where a reaffirmation is not signed, then the primary borrower who filed bankruptcy is not responsible for the balance of the loan, but your cosigner is. The cosigner will get sued for the balance, take a big hit on their credit score, and a repossession mark will appear on their credit report. The creditor will most likely sell the vehicle at an auction and sue the cosigner for the balance due under the loan. Well, under the surrender option, the same thing happens. You suffer no consequences, but the cosigner gets hit once again with a repossession mark on their credit report, and their credit is damaged due to the surrender. Plus, if the lender sells the car at an auction and if they don't receive enough money to satisfy the balance of the loan, then the cosigner is liable for that deficiency. There's a lot of liability when cosigning, especially when the loan amount is much greater than the value of the car. Let's take a look at the second area of the law, cosigning on a rental lease. If the renter gets evicted for non-payment of rent, both the renter and the cosigner are obviously responsible if the renter gets evicted. You can bet that the landlord is going to sue both the renter and the cosigner to get their money, and a judge is going to allow that due to contract law. If the renter, though, files bankruptcy and surrenders the unit to the landlord, guess who's going to get burned? Just like how it works with a car, the cosigner holds the bag. They owe any money due under the rental agreement. Cosigning is not a good idea. Now, I understand that parents want to help out their kids sometimes and will cosign on car loans or rental agreements or both. Bad things happen to the person who cosigned for the primary borrower or renter. Before cosigning, you need to evaluate the consequences, including bankruptcy consequences. I hope this video opened your eyes. I'm attorney Robert Flessas, and thanks for watching.